Wait.
From the daily list, item number 1.
May I please, Lordships? Lordships, I appear for the respondent 2 to 4, which is the Garoville's Autonomous District Council, my lord. This is essentially a challenge to one of the regulations passed by this Autonomous District Council. However, today, my lord, in this matter, we are being led by learned senior counsel, Mr. Jindal. He is unfortunately not keeping well. I'm praying for a short accommodation, my lord. We're being led by Mr. Jindal, my lord. They are challenging the regulation passed in 1954.
But is it for hearing today? Is it for hearing today? What is this for?
For hearing, my lord.
And the request of party, we said the matter came up before that. This matter can be.
Oh, yes.
He said this.
Yes.
He requested some other.
Yes.
The way the respondent.
Lordship, for the respondent.
The request of the respondent.
Respondent 2 to 4. Respondent number 2 to 4.
What's the matter? April. Give the date later.
Lordship. Highly obliged, Lordship.
After holidays.
Obliged.
Item number 2.
May it please, Lordship. Lordship, this is a similar matter, Lordship.
Note down the counsel appearing to respondent 2 to 4 is unwell in short time. Yes. Senior advocate is unwell. So the junior counsel on record short time. Yes.
Lordship, this is a similar matter, Lordship. And as per the last order, Lordship, we're supposed to bring on record those the rejoinder affidavit, Lordship. However, we're filing in the course of the day, Lordship.
You going to file a rejoinder?
Yes, Lordship. We're filing in the course of the day, Lordship. Lordship, may I kindly hear this matter after 2 weeks?
It is represented by the counsel appearing for the petitioner. That rejoinder is ready and the same will be filed in the course of the day into the registry. Short time. Post this matter on the same day.
Highly obliged.
2, 3, that's all.
From supplementary list, item number 1 to 3.
Applicant list or regular? Supplementary. Yes,
This is an appeal, my lord. However, there is a delay of 130.
136 days.
Yes, my lord.
No objection, my lord.
Click on no. Yes. What is the issue? POCSO or 302?
Reduced to my lord.
302. Yes. Click on no. Register is the active number and
From the daily list, item number 1.
Much obliged, lordship.
Obliged.
In appeal, lordship. This is an appeal by the Income Tax Department. Now, order dated 12/12/2022 under Section 260 of the Income Tax Act. Lordship, the appeal is to be considered on the substantial question of law. Lordship, I am placing four substantial lordship for consideration of your lordship. So, in this case, what happened? The SEC,
the notice go.
lordship.
Let the notice go. It's coming up for admission.
Yes, lordship. Lordship, I am submitting for substantial question of law for consideration of your lordship. I am submitting suggested substantial question of law for consideration of your lordship. Lordship, in this, my first contention is that the SEC, they are maintaining hybrid accounting system, which is not permissible under Section
So
140.
there is an appeal under 260A, is it not?
Yes, lordship.
There is order under 263.
Lordship. Yes, lordship. Lordship is to see whether there is any substantial question of law is there or not. Our basic contention before lordship, the accounting system adopted by the respondent is a hybrid system, but under Section 145 of the Income Tax Act, they have to maintain their account by keeping mercantile system of accounting, lordship. Because this,
We'll see. Question of law. The question of law. You take notice.
lordship.
You're appealing.
Your lordship, I am for the respondent.
A respondent, yes. Corporation. Power Corporation.
So led by Sir Vijay.
Yes. Senior advocate.
Yes.
Yes, lordship. Much obliged.
Still appeal. Question of law is here. This is not the matter. It's a new matter. This is the matter came up last time, no?
Yes, your lordship.
Lordship.
But this is the matter came up last time.
Yes, lordship.
And whether maintainable or not. This is the question we said only appears to be, serial number 3 appears to be
Yes,
the
lordship.
question of law.
Lordship.
But senior advocate said that there is one judgment
Yes, their contention is that,
operating against you.
Lordship, their contention is that there is a notification by the department, and on that notification, they are maintaining a hybrid system. Lordship, whether any notification can override the provision of law, Lordship. This will be my contention, Lordship. Lordship, may I examine if there is any, on merit, there is anything, Lordship.
So the question of law is only with regard to question number 3.
Lordship.
That's all.
Yes, Lordship.
Question of law with the admit notice, question number 3 alone can be framed.
Much obliged.
Yes.
Item number 4.
May please, Your Lordship. Lordship, I have filed the affidavit on response to the report dated 14/11/2023, filed on behalf of the respondent state. So, Lordship, in the affidavit, if you may kindly see in the paragraph number 5, number 4
Paragraph number 5
of the affidavit of the petitioner. Your Lordship, if I may take you to paragraph number 4, Your Lordship, that
Oh, this is regard to the livestock market.
yes, Your Lordship. So, what is the grievances of the petitioner here, Your Lordship, that
Yes, last time the provision was also brought to the attention, 8 or so, is it not?
yes, Rule
What is the provision?
8
The
of
provision,
Rule 8 of the Prevention of Cruelty. Lordship, from the main petition, if you can
so what happens
take
here?
me to
May it please Your Lordship. Lordship, we have filed a detailed report about the observation made by the petitioner. That the 3 markets, the livestock markets are still functioning. So Lordship, I'll have to take instruction, Lordship, like, because the Deputy Commissioner had issued notice to all these people. Now, what is the stage of
This is what last time also was stated. See, the rule is very clear.
Lordship is-
Last time somebody drew the attention of the court
yes,
to the rule.
yes, Your Lordship.
as per the rules, Your Lordship,
25 kilometers.
within 25 kilometers, Your Lordship. So the petitioner had brought this PIL saying that most of the markets within 25 kilometers should be shifted. After the PIL was filed, Your Lordship, we had filed a detailed report. We have taken steps, the Deputy Commissioner of different districts.
Taking steps to
To ask them to relocate or to comply with the provisions of it. So we filed a detailed report on 14/11/2023, and the petitioners were supposed to give further clarification on that. Now the clarification that has come today, Lordship, that this market is still existing within 25 kilometers. So can you give me
where is the rule? Where is the rule?
the rule?
Yes.
Rule 8.
So it was
Rule 8,
so last time we saw it in the typeset of papers.
Lordship, in our main petition, page number 8.
Page number?
Page number 8. Paragraph number 10. Rule of
Which one you are referring to?
petitioners.
Petition.
Yes, in our petition, main petition.
The order. Or rule number 8.
Yes.
You mentioned it.
Yes, Your Lordship.
Level Council of Petition submitted that the market is still in operation in the prohibited area and the distance to 25 kilometers as mentioned and rule has not been adhered to. So initially a report date is also has been filed. Going with the visualize the market is in existence. The petition submitted will file an affidavit. Today I filed an affidavit with
Yes, Your Lordship.
Lordship, Lordship, my submission is that we just received the affidavit. Their stand in the affidavit is this, Lordship, the state has not affected compliance of 25. Our stand on 14/12/2023 was, Lordship, that we have taken necessary action. Now, whether the action has been completed or not,
you go through it,
Lordship,
but ensure that it is not it should be in compliance with rule number 8.
absolutely correct, Lordship.
When the matter is taken up for hearing, the council for the petition submitted that a response to the affidavit dated 14th November 2023. Is it correct?
Yes, Your Lordship.
Correct.
14 November 2023 has been filed. Full stop. The additional advocate general would submit that wherever the distance is not maintained with regard to livestock market as contemplated in the Rule 8, comma, government is taking steps to provide them alternate place and ensure that there is the distance of 25 kilometers is maintained. You would further submit that he will go through the affidavit, comma, find out the exact position about the existence of the market and ensure that Rule 8 is complied with for getting instructions on the affidavit dated so and so now filed at the request of Additional Advocate General. Put the matter after 3 weeks.
Lordship.
Item number 5.
Yes.
May I please, Your Lordship. This part of the PIL in the service matter.
Ah, yes.
Lordship. My lord, my humble submission, my lord, is that 3 judgments are, my lord, in operation. One is, my lord, the 1998 judgment of Dhuridhan, where, my lord,
1998?
7 SCC 273, my lord, the judgment of Lordship had reflected in the order, my lord, 2 judgments.
Sir?
If Lordship may kindly come to the order of 16th February, my lord.
1998. Citation is 1998?
7, my lord, volume 7, SCC 273. This is, my lord, Dhuridhan Sahab case, my lord.
1998, 7 SCC 273.
Lordship.
Yes.
Lordship, in this judgment, my lord, it was one of the first judgments on this subject. It was held, my lord, that the PIL in service matters may not be maintainable, my lord. Thereafter, my lord, Lordship is also mentioned in the order of 16 February itself, a judgment which was reported in, my lord, 2010 9 SCC 655, titled as, my lord, Hari Bansh Lal versus 2010, my lord, volume 9, SCC 655. Hari Bansh Lal, my lord.
Name of cost title, sir?
My lord, it's Hari Bansh Lal. Hari Bansh Lal
Hari Banchlal or Justice Sadashiv.
versus Sahodar Prasad. Yes, Lord.
The citation is
2010 9 SCC 655.
2010 volume 9 SCC 655. Yes.
655, Lordship. If Lordship has this judgment, my lord, Lordship will kindly see. If I may start from the very head note itself. Lordships have it, man. Lordship, head note itself, my lord. Constitution of India, Article 226, Public Interest Litigation, Scope. Service
So
matters.
2010?
9 SCC 655. Hari Bansh Lal.
Yes. I don't have a copy of it. You don't have a copy. I think my brother is not having a copy. See? Only
They
one
were
copy.
reflected in the orders in the court, my lord.
See, when you rely upon certain documents, you must give it in the form of a typeset. Index it so that
Actually,
it's easy for us to
on the
refer.
earlier occasion,
The court officer also take it.
I apologize, my lord. I was under the impression that it was already there. I'm sorry, my lord.
Yes.
My lord, the head note itself.
Sir, the head note is not here.
Wait, Lord, I'm-
Letter patent in PAL matter, SLP against the
I'll start
judgment
from that
ordered by the High Court in PAL. That's what you want to read.
Lordship, if Lordship
What
will
is the
kindly
read?
come to para 14 then directly, my lord, to para 13, I'm sorry, paragraph 13.
This is Manupatra, yes. Yes.
Paragraph 13, my lord.
Okay.
Yes, it starts with in Duryodhan Sahu. Lordships have it.
Paragraph will be SEC will be different. Let them bring the SEC.
This is the hard copy, my lord.
Paragraph starts with which heading?
It starts with in Duryodhan Sahu, in bracket doctor, versus Jitin.
In Duryodhan Sahu only they said that is not maintainable.
Lordship, yes. Thereafter, my lord, the next paragraph.
1 minute, sir. 1
Lordship.
minute.
I'm so sorry about the confusion.
This is 3 judges, 98.
Lordship, yes.
3 judges, not maintainable. I think the judgment which you relied upon
Lordship.
is also a judgment of the 3 judges. Judgment by 3 judges.
2010, my
I
lord,
think
was a,
Justice M. Srinivasan has delivered judgment.
this 2010 judgment, my lord, is by 2 judges, my lord, Justice.
Yes. Which will prevail?
Now, if I may just point out, my lord, what has been held in this judgment. I'll try to satisfy, my lord, lordship, and just bear with me, my lord.
So only agreed persons alone are entitled to.
If I may just show, my lord, what I'm trying to impress.
What is your prayer in the petition?
My prayer is to set aside the appointment of certain school
To
teachers.
quash.
To quash these teachers,
To quash.
lordship.
You not sought for quaranto.
To quash their appointment because the appointment is contrary to the statutory, to the minimum eligibility criteria as per the rules. If lordship has, my lord, the
Duryodhan Sahu, yes.
lordship, Duryodhan Sahu, my lord, it was held in paragraph 18 of Duryodhan Sahu.
This also is not entertained.
Lordship, yes, this was in connection with, my lord, what was held, my lord, that is if the public interest.
Sorry, we will give you liberty. The agreed person can question it.
If I may just try to, Lordship, give me 10 minutes, I'll not take more than that. My lord. So in Duryodhan Sahu, my lord, it was clearly held that the PL was filed in the administrative tribunal by a stranger. It was held to be non-maintainable.
Correct.
Lordship may thereafter come back to, my lord, 2010, my lord, the judgment of 2010.
2010?
9 SCC 655, my lord, Hari Banshlal.
2010, yes. Yes.
Lordship will kindly have, my lord, paragraph 15, my lord. Paragraph 15, my lord, it reads the above principles.
Para 16.
15th, yes, Lordship.
14.
51.5, my lord.
1.5.
It's a one-line paragraph.
The above principle may except co-warranto public interest non-maintenance service matters. Yes.
Lordship, the above principles make it clear that except for writ of quo warranto, PIL is not maintainable in service matters. And the next paragraph, my lord, they have referred as to what would, my lord, a writ of quo warranto lies only when the appointment is contrary to the statutory provision, my lord. And lordship will also see, my lord, the next page, just before para 17, that is the extract from, my lord, the more modern corporation, that quo warranty can only be issued when the appointment is contrary to the statutory rules, my lord. So,
What is the proof that they have issued contrary to the rules?
Lordship, my contention in the PIL is that these teachers, an advertisement was floated for a post of certain posts of teachers, my lord, and these teachers were appointed in the government schools, and it is our plea, my lord, that MTET, which is the eligibility test, is required for all the teachers, my lord, and since these teachers seem to not have the MTET, my lord, that itself would amount, my lord, that the basic qualification as per the statutory.
That is a proof that in the rule says that they should process MTech.
Lordship.
And how do you say that they don't process MTech?
No, my lord. Now their stand on this aspect is that these teachers are not required to possess MTET because they are only teaching in class 9 and 10.
Where is the rule?
Lordship. Lordship will have the PIL, my lord, the PIL paper book.
Part 2 SPL.
Lordship. Page, my lord, 40
40?
40 of the PIL.
40.
40, my lord, annexure.
Notification dated 23/8.
Lordship, yes.
Yes.
Lordship will kindly see, my lord, minimum qualifications. So classes 1 to 4, my lord. At
Now you are concerned about 9-10. Is it
yes, my lord.
not? Where is that?
No, now, my lord, what I'm trying to say, my lord, this notification provides from class 1 to class 8. And for class 1 to 8, the MTET is very much required. And Lordship will now come to the, my lord, the advertisement. The advertisement.
Sir, please tell us in which class the teachers are going to be appointed.
From the advertisement, my lord, it is not clear that they are in which class they are supposed to be appointed. They are simply, my lord, assistant teacher appointed in so and so.
Where is the advertisement?
Lordship. Lordship will kindly come to, my lord.
So you can't take us back and forth. You must tell us correctly.
No.
See, this notification clearly says up to 8th standard.
Correct, my lord.
And you said that they are in 9th standard.
No, that is what they have said now. That is not our contention.
See, don't go by the stand. What is your case?
Yes, my case is, my lord, that they are teaching in all the classes, my lord. It is not clear from the advertisement.
How can we adjudicate on that?
If Lordship will see the advertisement, that's why, my lord.
Where is the advertisement?
Lordship will kindly come to, my lord, page 107, which is
107.
one of the advertisements, my lord. All are more or less same, my lord.
How can you say more or less 7? Yes, whatever it is. 107. Yes.
107, my lord. The advertisement is there. One assistant teacher's post so and so. The
107, 1 minute.
107, my lord.
Vacant post so and so.
And 2 posts for assistant teacher arts. From this advertisement, my lord, it is not.
BA, B.Ed, MA, B.Ed, lying vacant. Page number 40.
This BA, BSc, Lordship will see class 6 to 8. That is the qualification.
68.
6 to 8, the qualification required is BA or BSc, apart from the MTET.
Currently, executive is handed down, settle temporary appointments, or to replace a permanent employment. The regular decision stands rejected. Yes.
Now, thereafter, my lord, Lordship will also come to, my lord, page 109. That is another advertisement, very similar, my lord. 109, my lord. Advertisements are invited with mobile number, passport size photo, Xerox copies of all educational documents invited For the post of assistant teacher, qualification BA, BEd, salary as per deficit school norms, age 35 years as on 1st January 2023, 5 years relaxation for ST.
Madam, which standard they are taking classes?
Your Lordship, they are teaching in the high school, Your Lordship, 9 and 10. The MTET is required, it's only for the elementary school level, Your Lordship, from classes 1
When
to
you
8.
have an higher qualification
They are,
for teachers,
have a degree and a Bachelor of Education degree, Your Lordship. That is the required qualification.
what is it?
Bachelor of Education, BEd degree, Your Lordship.
The BEd. That
Yes,
is right.
That is what was given in the advertisement, Your Lordship. As per the advertisement, they have followed the rules. They have not done
No,
anything.
the advertisement should be in accordance with the rules.
Absolutely.
Is
Correct.
it in accordance with the rules?
Yes, Your Lordship.
Where are the rules?
MTET is not required for high schools, Your Lordship. It's only for the elementary schools.
Where is that rule? MTech is not required.
No, it is mandatory only for 1 to 8. That is the NCTE
So
notification.
you want higher qualification, higher qualified teachers for standard 1 to 8. Higher qualification is not required for higher standards.
Their qualification should be higher. Let me show Your Lordship.
What is it? It should be the other way.
No, Your Lordship. I would like to draw Your Lordship's attention to page 40. Your Lordship, for minimum qualifications for classes 1 to 4 at page 40, Your Lordship. They are saying that we have not followed this rule.
We are not concerned about this notification dated 23rd August. The rules. What is the qualification prescribed for standard 9, 10, 11, 12?
That is a degree in either science or art.
Where is the rule?
The rule is not here, Your Lordship, because on the last date, Your Lordship had asked me on 16/2/24 that I should only file an application for affidavit challenging the maintainability of the PIL. So accordingly, I filed a short PIL, Your
That is
Lordship,
right.
affidavit.
See, you have filed an affidavit showing that the writ petition is not maintainable.
Correct, Your
That is right.
Yes.
It doesn't mean that we cannot ask questions on other aspects.
Your Lordship, that particular rule, Your Lordship, I could not enclose it in my affidavit, Your Lordship. So if Your Lordship allows me, I can give a detailed affidavit.
You file because
A detailed affidavit enclosing all the
suppose the
documents.
qualification is not MEd or whatever it is, and it is the advertisement is in conformity with the regulations or the rules.
Yes.
Then that's enough.
Then we have no case, Your Lordship, yes.
Because this
But my contention is that, Your Lordship, since we are not teaching in the elementary school, MTET is not mandatory, Your Lordship.
So MTech is not mandatory for 9, 10, 11, 12.
No, Your Lordship. They need to have a
MTech
degree.
is required.
They need to
Higher
have a
qualification is required for LKG,
they
UKG,
have a
and first standard.
postgraduate degree or a degree and the BEd, Your Lordship, which is also a qualification which is higher, Your Lordship.
Which is higher?
No, MTET is only the Meghalaya teachers' eligibility test, Your Lordship. They are asked to conduct an exam, participated in the examination to show if they are eligible for teaching in the elementary schools. But for the higher classes, Your Lordship, they have degrees and the BEd. Well,
His Lordship will see page 41, my lord. Classes 6 to 8.
So first let them find the qualification, then we'll see. When will you file it?
Your Lordship, may give me 2 weeks' time, Your Lordship.
Should have come prepared with that. Counsel for the petitioner submitted that the writ petition in service matter is maintainable, and that when the appointment itself is in contrary to the rules or guidelines, the court can issue quo warranto. Court can quash the appointment. It is not necessary that agreed persons alone should approach this court. He also drew the attention of this court to the notification dated 23rd August 2010, wherein the higher qualification is mentioned, specified, and that pursuant to the advertisement mentioned in page number 98.
Advertisement is 109.
109, 109.
103, 109.
Sorry, 107 and 109. Teachers were appointed to take classes in standard 1 to 8, and that for the first time the respondent has stated that the teachers are appointed to take classes 9 and above. The counsel appealing for the respondent would submit that they filed a short affidavit stating that the writ petition is not maintainable in PAL. The writ petition is not, the PAL is not maintainable in service matter, and that the teachers who have been appointed pursuant to the advertisement referred to by the petitioner are taking classes in standard 9 and above. There is no higher qualification prescribed for standard 9, and that the respondent will file the rules for guidelines applicable for recruitment to the applicable for recruitment of teacher in standard 9 and above, to take classes in standard 9 and above.
Standard 9.
Post a matter after 2 weeks.
Lordship, I think it is classes 9.
Class of 9.
9, not standard, Your Lordship. Classes
Class of 9.
9 and 10, Your Lordship.
Class 9, standard 9, or 1.
Okay, but here we
Class, yes.
different, Your Lordship.
See, previously it was used to be said no. Fourth form, sixth form, seventh form, like that. It used to be stated like that. Ninth form, 10th form. Then they stated the standard in classes.
Much obliged.
Item number 6.
Teachers are appointed to ensure that the students come out of darkness and see the light.
Yes.
But you're surprised that you are prescribing higher qualification for a lower standard and basic qualification
Qualification is as prescribed by the central government, Your Lordship. It is not the state government that prescribes the qualification. As prescribed by the central government, that is what the state government follows.
Anyway, suppose you say that as long as the rules are not challenged, we are not on that. The Supreme Court is also very clear that the writ petition is not maintainable
In service matter.
in service matter.
Correct.
But if the appointment itself is contrary to rule, the Supreme Court says no or under will
Be issued, yes, Your Lordship. But in this case, Your Lordship, the appointment is not dehors the rules. And if, anyway, in the writ petition, Your Lordship, the petitioner has not mentioned anywhere that they are teaching in elementary school or in the secondary schools, Your Lordship. They are very vague on that point, Your Lordship.
What is it? Repeat.
In the writ petition, Your Lordship, nowhere has it been mentioned that these teachers who have been appointed and whose appointment they are challenging have been appointed either in the elementary school or in the secondary school. They are silent on that. The whole petition is silent on that.
What is it to that?
No,
The whole petition is silent on that.
We are saying that they have been appointed in the school pursuant to an advertisement.
So you cannot expect the court to conduct a ruling.
No, I am not
Because it
shooting
is
in the air.
silent, Your Lordship.
I am
It
not
is not-
shooting in the air. We have specifically stated that these teachers ought to have had the MTET qualification for teaching in this particular school. Now they come and say that in this school they are only teaching in class 9 and 10. That is why it is not required.
The whole petition is vague, whether we are teaching in the elementary school or in the secondary school. They have not mentioned that, Your Lordship. They have just said that we are not qualified to teach in that school. That is their contention.
Then we'll dismiss it on the ground that
Let them file the affidavit.
not required.
No, my lord, that is not correct, my lord. That is not correct.
That have been stated.
I have gone through the writ petition.
That have been
I
stated
can-
in your affidavit.
Show, my lord, again.
Sure.
Yes. They're silent on the classes that I am teaching.
It's a different case, huh? Yes. My name is stated. So why should you keep them at PA for years together, sir?
They're just saying school, school. No, it is neither said elementary school or secondary school, Your Lordship. But the name of the school itself suggests that it is a secondary school. Deficit secondary school.
Lordship will see below paragraph 20
There are 20 of your affidavit.
of the writ petition of the PIL.
Yeah.
PA list. Yes.
No, it's said.
So this was the information which we have received from the RTI.
Petitioners
that 12
of
teachers
12
were-
teachers are appointed various schools so also till date. Subsequent the appeals on appointment were made without any advertisement.
And the next,
However, the most shocking is that said information is relevant to the appears that none of the teachers were appointed till date by mandate.
They've not said whether these teachers have been appointed. They've not said whether these teachers have been appointed in the elementary school or in the secondary school yet, teaching in the secondary.
because that was not clear from the reply, my lord, because advertisement did not specify in which school, in which class they are teaching.
Then
If you want to file a writ petition, fresh writ petition, we are dismissing it.
Lordship may just allow them to put the rule, my lord. Then it will be clear. I have no, my lord.
but they
Sir,
have
we do not know. Suppose a teacher in the 9th standard taking class in standard 9 or class 9 need to take class number 8 in the absence of teacher.
No,
Naturally, they'll go take classes.
that is, I have no,
Then
no grievance with that, my lord. But only to
shooting
say,
in the air.
had the advertisement specified that these teachers are being appointed in class 9, and then we would have no case, my lord.
That they have no case at all because they're shooting in the air, Your Lordship, not knowing whether they are in the secondary school or in the elementary school, Your Lordship.
we'll dismiss it.
Lordship, if I may humbly submit, my lord, if it can be
I
observed that
will give you liberty. It's not,
only one prayer, my lord, only one prayer.
not required.
No, I'll not take time, only one prayer. If it can be observed that these teachers are teaching in class 9, 8 and only that's it, my lord.
We'll record it. We'll record the statement. We'll say that the petition is not maintainable. Yes. Who are you?
I'm waiting for item 3 where my voice was not reaching out. Your Honor, was on this NIPCO case, Your Honor, Northeastern.
Earlier items.
Which one?
You're on item number 5. You
We
start.
are on item number 5, sir. We are item number 5. Already the matter is over.
But my voice could not reach out at that time, Your Lordship. That was the only reason. When item came on.
No, you're there. Your system was not working.
Yeah. So my voice could not reach out.
I think we have framed the question of law. Item 3.
It is not required, Lordship, because it is covered by the Supreme Court judgment and High Court judgment.
That's what we said. The junior was here.
Hmm.
Yes. Just to note down this, the present writ petition will be filed, challenging the appointment of the teacher.
Of several teachers.
The affidavit is bereft of details as to which standard the teachers are appointed. The petitioner
We have
cannot.
stated that, Your Lordship, in affidavit. We have stated that they are teaching in classes 9 and 10. In our affidavit.
Huh?
In our affidavit, Your Lordship, we have.
Sir, he has not given the details. That's what-
That is the petition then, Your Lordship, not the affidavit.
What is
Sorry,
it?
Your Lordship,
Petition was not mentioned.
okay. In the
That's
petition,
what we stated.
I'm sorry, Your Lordship. I'm sorry.
Stop. The other reasons we have given for adjournment, those points we can add, is that though the writ petition, though the PL, the service matter is not maintainable, and an exception is drawn by the apex court in the decision reported in so and so, that warrant is permissible. Full stop. In the light of the judgment of the Apex Court, we are of the view that the present writ petition is not maintainable. And the petitioner will have to, the aggrieved person will have to work out the remedies, the manner known to law. So these are the, we'll elaborate it under. Reserved.
That observation may be there, that these teachers
Yes.
are not
We
teaching.
stated in affidavit.
That observation may be there, my lord.
Which observation?
That they are not teaching in class, only teaching in class 9 and 10. That's all.
The respondent's contention is that the teachers who have been appointed pursuant to the advertisement in page number 109 and so are taking classes, in standard number 9. I mean, class number 9.
9 and 10.
9 and
9 and 10.
Yes.
Obliged.
Obliged.
How many? 1 or 2?
Not
How many cases?
One.
my lord, only item 5.
Item number 6.
The order is reserved, sir.
Please, Lordship. This is an appeal against the order dated 8/5/2023 in WPC 377 of 2019, Lordship. Now, what happened, Your Lordship, the back of the cases? This is regarding, Lordship.
Which?
Oh, it's that imperial order is page 32. No, 132. 132.
This is writ petition against interim order.
Writ petition, we are
Final order.
challenging this order before this. We are,
Final order or interim order?
this is the final order.
The judgment.
Yes.
Now, against this order, we are coming before this court. It is file appeal. Now, the break of the case is, Your Lordship. This Garwin Autonomous Council is an autonomous body as per the 6th schedule, and this Autonomous District Council is given as per the Garo Hills Autonomous District Council Social Custom and USSS Balloting Act, that as per that rule, they were given to try the dispute of Akan case and also appointment of headman or Nokma, Your Lordship. Now, in this case, Your Lordship, what happened?
Who is on the other side? Ready?
Ready, madam. In this matter, Your Lordship, this the predecessor of the appellant.
Shall take up next week.
Lordship,
Because we have got inspection of the airport inspection is there.
Lordship.
Most immediately after holidays.
Lordship. Must place, Lordship.
Obliged.
Item number 7 and 8.
Petitioners in this matter. Well, pursuant to your Lordship's last order, we have been served with a copy of a report in the form of an affidavit. But with the greatest respect, my lord, this itself, my lord, establishes the case that, my lord, the amendment to, my lord, the Meghalaya bonded warehouse rules and, my lord, the Meghalaya excise rules were made by notifications, my lord, completely ultra-virus, my lord, the statute, and also, my lord, promote monopolistic, my lord, tendencies. Well, if your Lordship will kindly, my lord, see one. I'm sorry.
Who is on the other side?
Well, the state government is represented.
Two
I'm
matters.
in,
But I am in
I'm
next matter.
respondent.
Lord, the issue in this case is that government amended excise rules and bonded warehouse rules, and under these rules, government created central bonded warehouse for distribution of liquor and Indian IMFL, my lord. That rules came to be challenged in this writ petition, my lord. During the pendency of the matter, certain observations and orders have been passed by your lordship. Pursuant thereto, my lord, we have decided to create one more bonded warehouse, so that the allegation of monopoly should not be there, my lord. In that light, we filed the affidavit on the last date of hearing. Time was sought by the petitioner to respond to the said affidavit, my lord. Now,
Well, I do not wish to file any affidavit. I want to argue about the matter, my lord. I'm ready.
So
Well, this-
I take your
this
lordship,
challenge-
1 minute, sir, 1 minute.
if I take your lordship, the 23rd February 2024 order, my lord.
Oh, yes. The bench is that the matter be heard finally and a short read will be given. She submitted that if objections need to be filed after going through the affidavit based on liberty may be given to her to file objections.
Yes, my lord. So they do not wish to file objection now.
Yes, yes.
So the matter has to be posted for hearing, my lord.
Well, I want to argue on the matter because, my lord, I say, my lord, with the greatest of respect, that in view of the affidavit that has been filed, my lord, the challenge to these rules must succeed because it is admitted that, my lord, the rules as amended, my lord, create a monopoly, which cannot be permitted under Article 19. And, my lord, your lordship's previous orders also make it very clear that the rules, my lord, that have been amended, my lord, do not, my lord, leave a level playing field and, my lord, completely arbitrary or, my lord, open to malpractices. These are the orders passed by your lordship already in this matter. So, my lord, either, my lord, this petition succeeds.
Anyway, we'll fix a date for hearing in the month of April.
Yes. 21.
It is represented by the council appealing to the petitioner that they have no inclination to file any objections to the affidavit filed by the respondent, and that they are willing to argue the matter based on the available documents before this court. At the request of both parties, pose the matter immediately after vacation.
And for respondent number 3, I have already filed an objection.
Yes.
That is on record.
So you have
Any
filed-
date,
I have already filed one.
any date, my lord, we like to fix.
3rd April, if your lordship's convenience.
We'll give a date, sir, because after the holy holidays, we'll give a date in the week of April.
My lord, may I request your lordship to kindly, my lord, fix it only after the 8th of April. My lord, first week of April, I am in some difficulty.
So, well, no problem, after 8th of April. Yes.
I am very grateful. Very grateful.
It can be on the 9th, then let's get a date fixed. 9th, if it suits your lordship.
If it's convenient, 9th is.
I have no difficulty on the 9th, my lord.
Yes, we'll give a date, depending upon that, you chart and show me the date, thereafter we'll fix it.
Grateful.
Obliged.
Item number 9.
That is
We did.
last, yes. Union of India. Yes, sir, what is the matter about?
My lord, here what happened, my lord?
Coming up for admission. For 3 of 24. Who is appealing to the respondent? Last time the matter came up,
Last time also no one appeared, my lord. I think Mr. Kumar is there now.
what is the matter about, sir?
But here what happened, my lord? In Assam Rifles, on completion of 30 years of service, my lord, a service review is carried out.
No, see,
My lord,
where is the proof that he has admitted the guilt? I think we have passed an order recently saying that in case of admission of guilt, who is appearing?
My lord,
I am for the respondent.
there was some difficulty in the network, my lord. This issue otherwise, my lord, is pertaining to communication of ACR. The learned single judge basically had followed the settled law, which basically requires that the ACR should be communicated and a representation thereon should be filed, my lord. Now, the ACR, upon communication, my lord, I have filed my representation also. But in the meantime,
What is the punishment you have been given? ACR need to be communicated. What is the punishment that has been given to you?
My lord, it's not a matter of punishment, my lord. Here what happened, my lord?
It's not a case of punishment.
No, my lord.
Ah.
My lord, here, my lord, on completion of
But
30
it
years.
says that he has admitted guilty, etc., and all those things. Oh, you have the 5-year ACR has got to be returned.
My lord.
Ah.
my lord.
What happened, my lord? The respondent, who is an employee of Assam Rifles, my lord, on completion of 30 years of his service, my lord, a service review was carried out in terms of the rule which say that if somebody has become deadwood, my lord, he can be boarded out from the service.
Yes.
So that was done, my lord. And because of his low ACR, my lord, he was directed to be discharged from service on completion of 30 years of service, my lord.
Yes, please.
On completion of 30 years of service, he was directed to be discharged from the service. He was found to be a deadwood, not fit, not in public interest.
What was his age?
He must be around 55 now, my lord.
At that point of time.
My lord. Now what happened, my lord? They came before this honorable court contending that, my lord, that ACR for that period was not communicated to them. My lord, if I may pray, my lord, today the time may not permit, my lord. If you can take it up next week sometime, my lord.
Yes. Yes, yeah.
My lord. Otherwise, as per the single judge's order, we have filed a representation which is pending, my lord. They may consider it, they may not, my lord. But then at this stage, probably the appeal was
Where is single judge? Where is the order of another single judge, sir?
Well,
page 57.
What happened? What have you done with regard to the adverse entry? See, paragraph number 5 of the order of another single judge. This is 26th April 2022, is it not?
my lord, the impugned order is page 174, my lord.
174? Respondent to formally communicate the entries, enable the petitioner to make a representation. The petitioner may still thereafter listens also. Upgrade. The entries be upgraded. What is this, sir? Where did they consider and pass the orders?
My lord, there is a error apparent, my lord. Here what happened, my lord, this is not a case of denying promotion, my lord. My lord, lordship, kindly see para 7 of the order, my lord. Para 7 of the order. It says, my lord, it is further directed that should the entries be upgraded in consideration of the representation, the respondent authorities shall constitute a review DPC, a grant of consequential relief, my lord.
In case the decision is taken in favor of the petitioner,
My lord.
you will have to constitute. If you take a decision adverse, why should you do it?
My lord, here what happened, my lord, this was not a matter regarding promotion, my lord. This was a matter of discharge from service on
Instead of DPC, the word should be always review.
Yes, you'll hear the matter.
Anytime.
24.
Anytime.
Writ appeal is 2024. It's mentioned as 2023, some places. Yes. What's the matter? Immediately after. At the request of both the parties.
Well, deeply.
So get on with the matter, that's all. The next hearing.
Well, it's a short matter, my lord. But this was a matter pertaining to discharge from service on completion of 30 years of service, not a promotion, my lord. So there is no question of constituting a DPC, my lord.
No, the judge appears to have observed that for 2 years you have not communicated the ACR.
My lord.
You communicate, suppose a favorable decision is given in favor of the employee.
My lord.
Then the DPC will have to constitute it.
My lord,
and whether he is entitled to promotion or not, he is entitled to continue in service.
My lord, that is our case, my lord. The entire dispute is not about promotion, my lord.
Not with regard to promotion.
This is with regard to continuance of service or not.
Exactly after 55 years or 50 years, whatever it is.
My lord.
Suppose in 2 years adverse entries are taken away.
My lord.
Then he should be in service.
He should be continued in service, but the direction is to hold a DPC, my lord, for promotion.
That paragraph will remove it.
My lord.
That line we will remove it. You consider the representation. What do you say, sir?
My lord, it should be service review rather than DPC, my lord. In
No,
fact,
no,
the
no.
word
It should be
service
review, my lord.
service review rather than DPC.
Exactly. We will say that the DPC will be convened, and in case of any favorable order with regard to the two entries, then your service, whether your service will be continued or not, will be decided by them.
Madam.
We'll modify it.
By instead of DPC, it will be service review board. my lord.
Sir?
Service review board.
So, not DPC.
Not DPC.
Sir, we'll modify it.
My lord.
My lord.
That's all. So when the matter is taken up for hearing, both the parties are agreed by the observation made in para number 7 of the order at page number 173. 173 at 174, sir. Starts at 174 and the relevant paragraph is at 177. According to the appellant, Union of India, they have no objection in considering the ACR, reconsidering the ACR after communicating the same to the petitioner. Petition. But the observation made by the learned single judge that in case the adverse entries have got to be eschewed, then the authorities will have to constitute a review DPC for grant of consequent benefit is erroneous. According to the respondent in the writ petition appellant herein, the petitioner was treated as dead wood and discharged from service at the age of 55.
Well,
Stop. While considering the required representation of the petitioner, in case of favorable decision, so and so board, which
service review board.
Service review board alone can take a decision
Well,
with regard to continuation of service beyond 55 years
well,
and not with regard to grant of promotion and other benefits. Stop. The counsel appearing for the writ petitioner respondent herein virtually appeared and submitted that the representation made by the writ petitioner is still pending and no decision has been taken. If the surveyed board mentioned by the appellant consider the request of the petitioner after taking into account the uncommunicated ACR and in case of favorable decision, the board may pass appropriate orders within a period of
8 weeks from today.
8 weeks. Full stop. Taking note of submissions of both the parties, para number 7 is modified and it should read of the learned single is modified. It is further directed that should the entries be upgraded in consideration of the representation, the respondent of the authority shall constitute so and so board for grant of extension of service and other benefits if any, and that such exercise shall be completed within a period of 8 weeks from the date of a copy of the representation, if not already made, which shall be made by the writ petitioner within a period of 2 weeks. A decision shall be taken after hearing the petitioner in person or virtually. But we also make it very clear,
Yes,
the writ petitioner has already attained the age of superannuation. Is it not?
No, my lord.
I think it should be served. 55 means 3 years. Oh. It's not attained the age of superannuation.
My lord, there are 4 years of service left.
He is due to retire from service on 1/7/2022. At page number 174, the order of the learned single judge. Oh,
That was as per
retired
my
at age of
lord.
55. Yes, yes. Now, the
But
last
if I
sentence,
retire-
yes, last sentence is not required. Yes.
My lord, 8 weeks, my lord, earlier 6 months was granted. My lord, may I pray for 12 weeks, my lord? To complete exit.
My lord.
Deeply.
Your Honor. Four months from the date of register of the order. Yes.
Deeply.
What is the matter about, sir?
My lord, my lord, here, my lord, the petitioner
Regularize the services.
My lord, what? No, my lord. What has happened in this case, my lord? The petitioner was serving as assistant teacher, my lord, since 1986, my lord. There is one government-aided school, my lord, which is the private response number 34, my lord. Here, my lord, in the year 1986, my lord.
So what is the relief sought for in the writ petition?
My lord, what has happened, my lord? I had been, since 1986, I had been working till 2018, my lord. So, my lord, suddenly, my lord, the state respondent has directed the managing committee to advertise the post which is being held by me, my lord. I'm in the verge of my superannuation, my lord. So, the brief fact, my lord, is that this government-aided school, my lord, it has got 3 sanctioned posts in the lower primary section, my lord. So in 1986, my lord, I was appointed in the upper primary, my lord. Now it so happened, my lord, in 1997, my lord.
What about you, sir? Ready?
My lord, only difficulty I am having due to cold and cough, my lord, even my voice is affected. My lord, if it is taken,
With the council, you are appealing for?
I am for the state.
Now the request of the state.
My lord.
What's the matter? In April. If the council represents that he is not well. Yes,
Deeply obliged.
Obliged.
From the being this, item number 1.
Lord, this matters, my lord, has been adjourned because a connected issue, my lord, the SLP is pending.
Where? SLP.
My lord, last several orders actually has reflected that because of that pendency, my lord, the matter got
Pending
adjourned.
where, sir? Pending? Supreme Court.
Pending in the, my lord.
Pending?
Manas, that matter, what is pending before Supreme Court is altogether different, my lord. This, the issue in
It
this.
will be listed in the month of July.
The month of?
July, my lord.
Wait, we'll go there also.
My lord, this matter is totally different, my lord. In fact, on their submission, but when I opened the petition, my lord, the prayer is totally different. The subject matter is totally different.
What is that prayer and what is this prayer?
My lord.
Similar benefits have got to be extended.
My lord, page 28, my lord. The main prayer, which is the second prayer, my lord. Page 28.
Page 28. Yes, mandamus, no.
Directing the respondents to grant petitioners promotion to the rank of Naib Subedar AA vehicle equal to MTech.
Grant classification of pay group, appointment of so and so, as well as a paramedical so and so. Division bench order is also there. There's Sanjeev Banerjee, division bench order is there.
My lord, that SLP is pending against that, my lord, but subject matter there was totally different, my lord. That is in my humble submission, my lord. But I have no problem with the matter yet, John, today, my lord. But
you see, why should we? What? Though the counsel appearing with the respondent submitted that the issue is not connected with the SLP that is pending before the apex court, counsel for the petitioner submitted that once the issue is decided with the apex court, the entire matter will be given quietus to, as the issue will be covered by the decision that may be rendered by the Supreme Court. He also submitted that in case of any adverse decision against the petitioners, writ petitioners therein, he will not submit that this case will have to be argued on a different context, taking note of the submission. So once that is over, he will close it. So we will not give him a room. If such a stand is taken, it amount to the court will have to take into account that there was a misrepresentation before this court. Post the matter on 19th August. The matter is pending, coming up before the Supreme Court in July. Specific dimension.
My lord, it says 1st of July, my lord, 1st of July.
Post is for July? Yes.
Item number 2.
May I please, Your Lordship? This is a matter by which, my lord, I am challenging the appointment of the private respondents. There was an advertisement, it is on Annexure 4, my lord.
Who is appearing? Readings are complete?
Yes, my lord.
Readings are complete?
Yes, sir. Yes.
Yes.
Yes, my lord, may kindly come to page Annexure 4, my lord, page 31.
No, we'll take it after, because we were having an inspection.
Yes, but I was
Shillong Airport.
My lord.
What's the matter? For your sake only. Yes. What's the matter? Immediately after holy holidays.
Item
The
number
month of
3.
April.
My lord.
Number 3.
My lord, this is again the matter where, my lord, the municipal employee has approached this honorable court for not paying his salary, my lord.
1 minute. Submitted that the respondent for 5 years on initial department action, so also contended the initial substance of the parent. She is not aware the present status and continuation of present substance. Weeks time to assist the court. We expect the concerned authority who is responsible for the disposal of services and conduct and also appear. Oh, she is present.
Yes, the CEO of municipal is present, my lord.
Yes.
I may humbly pray, my lord, that if some time may be given in this matter also, so that I can, earlier, my lord, she has taken the charge, my lord. I need to have a thorough discussion about this matter, my lord, and I can place properly, my lord, the facts of the case.
Yes. When the matter is taken up for hearing, the officer so-and-so has appeared through video conference. The counsel appearing for the respondent submitted that The officer has rejoined recently and he'll ascertain the exact position and inform the current status
Yes, my lord.
before the court in the next date of hearing.
My lord.
Post the matter after the holy holidays.
Hello, Lordship.
Authorised, Lordship.
That's all.